Good evening, and welcome to the launch of Volume 47, Issue 4 of the University of New South Wales Law Journal. On behalf of the journal, I would like to begin by acknowledging the Gadigal peoples of the Eora Nation, the traditional custodians of the land on which we gather this evening. We pay our respects to their elders past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander peoples joining us this evening. My name is Sharanya Mathi, and I am the Executive Editor of the University of New South Wales Law Journal for 2024. It is my immense privilege to commence tonight's official proceedings for the launch of Volume 47, Issue 4, a part thematic on the topic Equity, Conscience and Commercial Morality. As are all journal launches, tonight's launch is special for a number of reasons. Firstly, I would like to welcome the Honourable President Julie Ward, who will be responding to this issue's theme. President Ward is currently the President of the New South Wales Court of Appeal after sitting in the Equity Division of the Court and being a partner here at King Wood Mallesons in 1998. A more fitting keynote speaker would be difficult to find. Secondly, tonight we are here to celebrate all the people who have made this 334-page issue come to life. This includes our student editors, suppliers, cover designers, typesetters, artists, UNSW Law and Justice faculty, sponsors, peer reviewers, academics, and countless family and friends who have led us to here tonight. Most importantly, we thank the authors of this issue, some of whom are here tonight, including the journal's very own forum editor, Jack Sau. We thank you for entrusting the journal with your scholarly works and for bearing with our rigorous editing process. We hope you are more than satisfied with the work that is in your hands right now. Next, we are here to celebrate the journal itself and highlight some of the journal's key attributes which make it special and unique. One key attribute of the journal is its generalist nature, meaning there is no one legal topic we are tied down to analyse. This leads us to examining a gamut of contemporary legal issues. In 2024, the journal has published 4 volumes, 40 articles, 1,004 pages, varying markedly in subject matter and analysis. From investigating conversion practice reforms in Issue 1 to the effectiveness of anti-corruption commissions in Issue 2, and in Issue 3, examining the effects of the newly instated coercive control legislation in New South Wales, to now looking at corporate alter egos, for-profit companies as slaves, and the extent of fiduciary obligations in Issue 4, the journal has always stayed on top of diverse, varied, and fascinating legal trends. Speaking of which, the journal has been cited in some significant judgments this year, including Lerman and Network 10, and 6 High Court judgments on matters pertaining to public interest immunity, judicial review, and legal professional privilege. The extent to which the journal has been referenced by Australia's highest court and in high-profile legal cases is a testament to its relevance and commitment to highlighting pressing legal topics which are at the crux of judicial decision-making. The journal is also committed to increasing access to academia. We are dedicated to ensuring everyone is able to access the scholarship we publish, being available for free on our website and in many online repositories, meaning anyone from anywhere can access the journal. Our online short-form companion, the forum, also ensures ease of access for students, academics, and editors alike. We are extremely proud of this. Another characteristic of the journal is its entirely student-run board, a fact which oftentimes seems to shock people. Comprising of 48 students in all different stages of their law degree at UNSW, the board has students fortified with a sense of diligence, drive, a passion for academia, and a lot of jest, humour, and friendship. The student editorial board are responsible for checking, double-checking, and triple-checking every footnote in the articles published, ensuring not a word, comma, hyphen, or full stop is italicised or formatted incorrectly. Editing is no one-person band, and our editorial board makes it seem like a flawless symphony. Most importantly, to my fellow members of the Executive Committee, currently consisting of 5 issue editors, 1 digital editor, and 1 forum editor, tonight would not be possible without you. Throughout this year, we have taken on roles much greater than those stated on paper. We have been responders to anxious late-night messages, voices of second opinions on interpretations of the most particular of AGLC rules, and most importantly, friends who we can rely upon. It has been my great privilege to lead this journal for the past year and work so closely with all of you. I am so proud of everything we have achieved this year and cannot wait to see what next year's executive committee, run by Ophelia Zhao, James Elliott, Alicia Lau, as the new executive, forum and digital editors, have in store for the journal's 50th year of publication. Particularly, tonight is a celebration of the editor of issue 47.4, Rowan Gray. Rowan is the journal's youngest issue editor in its 49 years of running. This often surprises people, as Rowan may be only 21 physically, but intellectually he oftentimes seems to have the brain of a tenured professor. Armed with the most extensive knowledge of equity I have ever seen a third-year law student possess, Rowan is quick to have an answer to any question, be it legal, philosophical, or one about e-gaming, and is one of the hardest workers I have ever met. On behalf of the Executive Committee, I can safely say we are so proud of what you have achieved so early in your degree and are excited to see what you achieve next. We have every confidence in your successor, Bisesh Belbase, will continue all of this with ease. My thanks also go to the UNSW Faculty of Law and Justice. In particular, our two sage and learned faculty advisors, Professors Rosalind Dixon and Gary Edmond, who are quick to remedy any pickle, and Professor Andrew Lynch, Dean of UNSW Law and Justice, who is here tonight and is an ardent supporter of the journal and all its missions. Lastly, launches are a chance to celebrate the extraordinarily generous contributions of the journal's premier sponsors, including King Wood Mallesons, Allens, Cause Chambers Westgarth, and Herbert Smith Freehills. Most importantly, we are here to thank King Wood Mallesons. This launch would not be possible without the continuous support of the firm, hailing as far back as 1987. King Wood Mallesons have continued to maintain their unwavering support for the journal, without which the journal would not be able to maintain its status as one of Australia's leading academic law reviews. For that, we are ever so grateful. Thank you all for joining us tonight for issue 47.4's launch. It is now my pleasure to invite Damien Lovell, partner at KWM, to speak on behalf of the firm.
Thanks, Sharana. And on this sunny evening, I would also like to begin by acknowledging the traditional owners and the custodians of the land on which we meet today. My name is Damien Lovell. I'm a partner here at King Wood Mallesons in Sydney, and it's my pleasure to welcome you to the launch of the latest issue of the New South Wales Law Journal, Volume 47, Number 4, on behalf of King Wood Mallesons. And in doing so, I'd like to extend a special welcome to our keynote speaker of this launch event, the President of the New South Wales Court of Appeal, the Hon Justice Julie Ward. As Saranya said, this is a long-standing relationship that the firm has with the UNSW Law Journal, and particularly KWM's sponsorship has gone over. I'd like to put a little editorial comment there. I've been told it's over 40 years, so it goes back to 1981, and when the firm was known as Stephen, Jakes and Stevens, and that coincided with the publication of the first thematic issue of the journal. In the foreword of that issue, it was stated that the adoption of a thematic issue was done in the belief that it would constitute a worthwhile innovation in legal scholarship. And so it has proven. And now, of course, there are 4 issues a year, and 2 of them are thematic. Back then when it started, there were 2 issues a year, and 1 of them was thematic. So times have moved on, and there's been an expansion of the publication of each part. The theme of the second thematic issue for 2024 is equity, conscience, and commercial morality. Those who know me would say that I am a bit of a law nerd, and so I am pleased that I will have some new reading over summer that considers a range of topics dealing with equity and commerce, and that are particularly relevant to my work as a dispute resolution lawyer. And on that note, again, I welcome you. Please accept KWM's congratulations to the UNSW Law Journal editorial board, and Rowan Gray, the editor of the issue, number 4 of volume 47, and I now invite him to speak to introduce the issue. Rowan?
Well, thank you very much for that warm welcome, Damien. I'm very grateful to see so many people here tonight. The room is completely packed. And our relationship with KWM is a very special one to us. So that, it really means a lot to us. As you've heard, my name is Rowan, and I am the editor of Volume 47, Issue 4 of the UNSW Law Journal. As issue editor, my job tonight is to introduce issue 47 and give you all some insight into how it came to be in your hands tonight. But I want to start off, though, by telling you a little story from 15 years ago. Now, if you're quick with maths, you'll know that's 2009. If you're quick with maths and somehow a lawyer, you'll be probably thinking, the global financial crisis, like seriously, we're way past that, that's old news. I actually don't want to tell you about that. I want to tell you a little story from my childhood. Now, when I was a kid, I was very well behaved, a real goody two-shoes, followed the rules to a T, and absolutely would get very upset when other people didn't. But don't let that fool you, because I adhered to the rules for the most part out of self-interest. You see, I thought that when you have a set of rules that everybody follows reliably, you can use the rules against themselves to get what you want, to use the rules against the rules. So I'll give you an example. In first grade, we had to work through a reading comprehension booklet over the course of a term. And one day we got to the last few pages of the booklet, and after receiving instructions, we were told that as soon as you finish, hand in your work, you can go and play. Well, nothing like an incentive, right? So I worked very, very hard, handed in it early, brought it to my teacher. But my teacher told me I wasn't allowed to go play. I was told that I had to first colour in the front page of the booklet, which until then I had left blank. Infuriating, but not to worry, I had a solution. The explicit instruction was to colour in the page. There was no requirement that the page had to look any good. So I grabbed a handful of the nearest crayons and scribbled madly on the front. There you go, all coloured in. I'm off to go and play. Now, my teacher was obviously not very happy. Why tell that story? The point is one which those familiar with the law of equity will probably have seen coming a mile away. As Henry Smith puts it, because regular law seeks generality and ex ante certainty, it cannot handle situations in which intense interactions can lead to unforeseen and undesired results. This was a point first made, albeit in a more primitive form, by Aristotle. It is a principle which runs throughout equitable jurisprudence and is perhaps the most cited explanation for equity's existence. Equity's role is to correct injustices caused by deficiencies in the common law. Perhaps a little blame can be placed on my teacher for, in my respectful submission, wording the order a little poorly. But of course, the fault was all mine. I had tried to use the rule to go against the policy of the rule. This is all to illustrate that, to me, equity has always been the most fascinating area of law. It is so intimately concerned with justice, with the frailty of human relationships and human constructs, and the reparation of harm, that, as Justice Gummo put it, our legal system would be incomplete without it. But that's all putting it a bit too broad, and this is where issue 47.4 comes into play. Issue 47.4, as Sharanya mentioned, is a part thematic, part general issue on the thematic topic, equity, conscience, and commercial morality. In the words of Justice Beach-Jones, it may not have quite the rhetorical ring to it as liberté, égalité, fraternité, but it was the best that I could do. For your reading pleasure, you'll find that the articles within the thematic component have been ordered accordingly. The first three, by Jamie Glister and Kalida Tang, Maxon Williams and Jack Zhu, on equitable doctrine generally. The next two, by Matthew Canaglin and Mark Giancastro, looking more specifically at the idea of conscience in equitable jurisprudence. And the final two, by Jordan Tudden and Vivian Brand and Duncan Wallace, looking more broadly at commercial morality. That is, the role that moral and ethical concepts have in commercial law and regulation. If there is such a thing as a single bright thread running through the law of equity, it shines through the articles in this issue, each individually and when viewed with each other in this way. Now, the journal has always been very proud of three things. More on numbers 2 and 3 later, but the first is our scholarship. More specifically, the quality, currency, and impact of the scholarship we publish. It's no surprise, given the faculty's passion for and commitment to social justice, that the journal has a similar reputation for publishing articles that have a strong social justice purpose. We also have a long-standing reputation for publishing articles that address pressing and important legal issues that are front of mind in the Australian legal landscape. The general articles within this issue, written by Rhys Blackett, Peter Spiro and Marianne Clausen, and Benjamin Haywood, are all this and more. But you wouldn't be alone then if you came here tonight thinking that the thematic equity, conscience, and commercial morality is somewhat out of character for the journal. The articles within this issue are certainly of the highest quality, but I'm not fooling anyone by saying that the average Australian, faced with all the difficulties of the modern political climate, really cares all that much about fiduciary duties or the law of trusts. That, however, was exactly why I chose this thematic. For one, academic currency, very different to political currency, but more importantly, this thematic was an opportunity to pull back the curtains just a little bit. And rather than take the typical regulatory approach, to zoom in on how the law affects the incentives and actions of private parties behind the scenes. More specifically, how equity and its focus on conscience and inter-party justice produces justice more broadly in the marketplace. And so, as Professor Matthew Harding has pointed out, equitable doctrine affects the public interest in many ways, more broadly by affecting the way that commercial parties interact with each other and what they see as acceptable conduct in the marketplace. Commercial morality, though, is a much broader concept and a bit of a fickle one. We live in a culture that glamorizes wealth and status, so it's not surprising then that appeals to commercial morality are often disingenuously brushed aside as naive and unrealistic, despite the large body of literature on the matter. Commercial lawyers are often portrayed in media as ruthlessly hardworking, but largely unconcerned with the moral quality of their clients' actions. Likewise, the expectation that large corporations will pursue profit above all else is so much the norm that to question why ethical considerations are sidelined would most certainly brand oneself as naive. As Sharanya mentioned, given my age, I'm likely to be branded that anyway, so I guess it doesn't matter so much for me. But what this thematic does in fact show is that lawyers and the legal system are very concerned with the morality, generally speaking, of private commercial conduct. Most young people, when you ask them what they want to be when they grow up, will say they want to make the world a better place or make a difference. Whatever that means, the general consensus is generally that it doesn't mean being a commercial lawyer. This issue questions that consensus. It highlights the many ways in which commercial law and commercial lawyers as its architects produce a marketplace with a far greater baseline of ethical conduct than would exist without them. That in itself is a worthy cause and should not be overlooked or peremptorily dismissed as naive. I'm so grateful to the authors in this thematic for trusting in this process and in my vision for this issue, however naive you see it. To the authors, tonight is first and foremost a celebration of you. Thank you for being so brilliant to work with throughout the editing process, and it's so great to see so many, I think a record by the way, here tonight with us to enjoy the fruits of your labor and to celebrate. And that brings me to the second thing which we at the Journal are so proud of, the strength of our relationships. First, to our premier sponsors, Allens, Cause Chambers Westgarth, Herbert Smith Freehills, and of course, King Wood Mallesons, thank you for your ongoing support of the Journal's work. The generosity of your support is a constant source of encouragement for us, and a reminder of the important relationship between the profession and legal academia. Thank you especially to KWM for so generously hosting this launch, to Damien, to Sarah, Suzanne, and the rest of the team for your work behind the scenes, planning everything so meticulously. On that note, in the Australian Academy of Law's annual Patrons Address in 2019, Chief Justice Kiefel spoke of the important relationship between legal academia and judicial decision-making. One notable point made by the Chief Justice was that the dialogue between academics and judges is often carried by the practitioner as messenger, when practitioners use academic writings to make submissions. So I look forward to hearing through the grapevine, and Damien's already hinted at this, of an uptick, a remarkable uptick in citations of the UNSW Law Journal in submissions made by KWM lawyers. In any case, thank you to all the young lawyers, clerks, summer clerks here tonight from KWM, and if you'll forgive me a little foreshadowing, hopefully it will be one of you back here as a judge one day to deliver a similar keynote address. Second, to the UNSW Faculty of Law and Justice, led so brilliantly by the steady hand of Professor Andrew Lynch, I simply cannot thank you enough. At previous launches, Andrew has spoken about how the faculty gets the benefit from the reflected light of the journal. But I think it works just as much in the other direction. The very character of the journal, as I said before, is so intimately connected to the character of the faculty, it's no surprise, as I mentioned before, that the journal has the social justice-y reputation that it does. In the journal is the very manifestation of the faculty's mission to communicate to its students a keen concern for those on whom the law bears harshly. Thank you to the members of the faculty here tonight who braved the potential trauma of seeing students whose papers they might have been marking over the past week. Chris Pierce, wherever you are. And thanks especially to Professors Rosalind Dixon and Gary Edmond, our ever faithful, ever reliable faculty advisors, who we can always trust to have our backs with anything. The third and final thing that we are so proud of, and you would have heard it a million times by now, is that we are an entirely student-run journal. To our boardies, the AJLC is not just a referencing system, it's a lifestyle. That's probably a weird thing to say about a referencing system, but I guess familiarity breeds contentment. Thank you, each and every one of you, for the hard work and long hours you put into this issue. It really means so much to me. Given that issue 47.4 rounds out the year, this launch is also a celebration of three very humble people and very important to the journal's work: our executive editor, Sharanya, our forum editor, Marcella, and our digital editor, Rachel. The work that these three have collectively put in this year to running the journal behind the scenes has just been phenomenal. I once likened the dynamic between Sharanya and the rest of the executive to the dynamic between Snow White and her 7 dwarves. But I am under strict orders not to disclose any more of that analogy. In any case, it has been an absolute privilege to work alongside such brilliant and hardworking people, so thank you, each of you. To the rest of the executive committee, thank you for your friendship and encouragement over the last 14 months. For me, you've all been like a second family, and I loved every second of the journey, not because I loved the AGLC so much, heresy I know, but because you were all there with me. Thank you also to my friends who listened to my rants about the AGLC and old chancery cases like it was the most normal thing they'd ever heard, for your patience and your kindness. Well, that brings me to my final responsibility as issue editor before I get off to do my summer reading. Well, I've already done it ahead of time. To introduce our keynote speaker for tonight, the Honourable Justice Julie Ward, President of the New South Wales Court of Appeal. Justice Ward studied law at the University of Sydney, graduating with the University Medal, and subsequently attended Oxford, graduating with a BCL and first-class honours. Her Honour became a solicitor at this firm, at the time known as Mallesons, and became the youngest person ever at the time to be made partner. Her Honour was appointed directly from her position as partner to the Supreme Court of New South Wales, the first woman to have been so appointed, and was later appointed to the Court of Appeal as Chief Judge in Equity and finally as President of the Court of Appeal. Her Honour has presided over numerous cases during her time on the bench, including some of the most complex and contested pieces of commercial litigation in New South Wales, and many of her judgments have been considered seminal in the development of equitable jurisprudence. In fact, in this issue alone, you'll find more than 30 citations of Her Honour's judgment. Challenge you to find them all. I would also like to thank Justice Ward for penning the foreword to this issue. It is an absolutely delightful read, and I encourage you to have a look if you haven't already. Please join with me in welcoming Justice Ward.
Well, thank you very much for that wonderful introduction, Rowan. Thank you, Sharinya, Damien, and all of those who are here today. I add my acknowledgement to the traditional custodians of the land on which we meet tonight, the Gadigal of the Eora Nation. It's a very great privilege to have been asked to write the foreword for this issue of the UNSW Law Journal, the fourth in issue series this year, and to launch it tonight. The last book launch that I did in this very room was a slightly longer book. It was 2 volumes, 1,194 pages, numerous footnotes, and it was the history of KWM. So, tonight I had Perhaps you might think I had an easier task, but in fact, the articles are very academically challenging and interesting, and so I couldn't say that 134 pages necessarily equals 1,194 pages of the KWM history, but it was a close run. Now, apart from the fact that the practice of equity is dear to my heart as a former Chief Judge in equity, it's also a privilege to be able to launch this edition at King Wood Mallesons offices, where I carry very fond memories of my time as a solicitor and partner. It is a bit of a worry that I was admitted almost as long ago as the first of the UNSW Law Journals, but I'll put that to one side. I congratulate the authors, and I congratulate Rowan and the broader UNSW Law Journal team on this production. Now, when writing the speech tonight, I was reminded of an observation made by a modestly known playwright, one William Shakespeare, in Hamlet. "Conscience doth make cowards of us all." Now, while my aim is not to bring some of you back to your HSC English days, Shakespeare does seem to infer that morality requires a degree of bravery. In the realm of law, conscientious hesitation becomes a driving force, urging us to seek fairness beyond the constraints of established legal doctrines. It's not to say that this practice is easy. Instead, it appears, at least in our friend Hamlet's case, that the exercise is increasingly difficult. In addressing tonight's theme, equity, conscience, and commercial morality, I will first outline briefly some of the historical origins of equity and analyse its impact on Australian legal jurisprudence. Given that my foreword focuses largely on the evolution of equity from the ancient Greeks and Romans to the English Court of Chancery, I've chosen to focus my address much closer to home, on the development of equity in New South Wales. This is particularly fitting, given the recent bicentenary celebrations of the New South Wales Supreme Court celebrating 200 years of justice in this state. Now, I'm not sure how long you thought I was going to speak, but I warn you that it'll take a long time to outline 200 years of history and development. But what I thought I would do is just briefly outline the development of equity in New South Wales from 1824 to 1970, known as the pre-judicature era. And second, after examining the evolution of equity and the common law, I will turn to a brief discussion of the articles contained in this issue of the journal. While our journey in terms of the history of equity ordinarily begins in the Greek tradition of, and I'll no doubt mispronounce this, epiekia, and traces its way to the English Chancery, the voyage tonight will begin on the 17th of May 1824. That's when the Supreme Court of New South Wales was first established, with both criminal and civil jurisdiction. The court's formation, now over 200 years ago, was pursuant to the Third Charter of Justice, issued under the authority of the New South Wales Act 1823 of the UK, and empowering the parallel administration of common law and equity. Notably, as the practice of Westminster courts in the United Kingdom evolved, the reverse process was occurring in New South Wales. For some time, New South Wales practiced its own form of conscientious hesitation by rejecting the newly implemented English Supreme Court of Judicature Act 1873. Under that Act, old higher courts of the United Kingdom were abolished and a new Supreme Court of Judicature was created, consisting of the High Court of Justice and the Court of Appeal. This was especially notable given that other common law jurisdictions such as Canada, New Zealand and the United States also favoured this concurrent application, often controversially referred to as the fusion of common law and equity. This concept of fusion is one that I'll return to shortly in this address. According to Section 6 of the New South Wales Act 1823, trials of civil actions were either to be determined by the Chief Judge of the Court, with two assessors, either as magistrates or justices of the peace, or a jury of 12 men. Looking to the Supreme Court of New South Wales now, it's clear that attitudes towards women in the law have changed for the better, but in those days it was 12 men good and true. Its matters of equitable jurisdiction, on the other hand, were exercised by judges of the New South Wales Supreme Court. Few of the early judges practised or presided on both sides of equity and common law. Equity cases were tried in court with distinctive pleadings, without oral evidence or juries. The New South Wales Supreme Court continued to wear two hats. A judge wearing his equity hat could issue a common injunction restraining the parties from continuing a common law action and requiring the parties to commence a fresh equity suit. By 1963, 3 dedicated judges sat on the top floors of Mena House on 225 Macquarie Street on matters relating to equity. Notably, one of the leading counsel who practised significantly between ministerial duties and other appointments was the late Sir Nigel Bowen, who became later the Chief Judge in Equity in the Supreme Court of New South Wales in 1973, and with whom I was able to work as his associate when he later was the first Chief Justice of the Federal Court. There are many stories I could tell you about working with Sir Nigel. Probably the most interesting was the time I was confronted with the self-represented litigant appealing a bankruptcy order who came in wearing a flasher's coat and 12 large knives. Sir Nigel informed him that it was not necessary for his security to have those knives there and he could just hand them to his associate. When the police had come to tell Sir Nigel that he was there with the knives, Sir Nigel said, "Don't worry, my associate sits in front of me." And the end of that story was that the gentleman in question, whose name I do recall but won't defame by repeating now, insisted that he wanted a receipt for the knives. Sir Nigel told him, "We don't issue receipts." So, coming back to my topic, there were significant disadvantages to the separation of law and equity. Adopting the contemporary vernacular of my tipstaff, not to plug, but the recently published New South Wales Supreme Court Bicentenary book, entitled Constant Guardian Changing Times, refers to the fact that suits of equity were riddled with prolix and procedural complexity and understood by very few. I know some practitioners that you could say the same of their pleadings today. As opined by the United Kingdom Judicature Commission in 1869, in courts of equity, quote, "the forms of pleadings are different, the modes of trial and taking evidence are different, the nomenclature is different, almost every step in the cause is different. There are cases of common law courts refusing to recognise equitable rights, titles and interests, giving rise to the very reasonable fear that a plaintiff might commence an action in the wrong jurisdiction, as seen in the case of Coroneo and Australian Provincial Assurance Association, where a common law action was dismissed without a trial by Chief Justice Jordan on the basis that it was quite clear that the proper remedy was a suit in equity. As such, it was said by Justice Dowling that the amount of equity suits was small compared to other branches of jurisdiction. It was calculated by Justice Leeming, who is very much in favour of statistics, in his honours paper Fission, that in 1844 around 10% of judicial resources were devoted to equity. This was until the implementation of the Supreme Court Act 1970. Now, at this point, I wish to discuss two fallacies of equity that may perhaps answer questions as to why the Supreme Court of New South Wales, one of the oldest superior courts in the common law world, was slow to adopt England's Judicature Act. The first fallacy, best put by the aforesaid Justice Leeming in his honours book Common Law, Equity and Statute, and I promise you I'm not plugging his honours books, was that equity was a collection of exemptions to strict common law rules. That is not the case. If one were to share my passion for all things pertaining to footwear, one could akin equity to that of a cobbler, who customises a shoe to fit an individual's unique measurements, adjusting legal principles to ensure that they fit the specific circumstances of each case, ensuring a better fit for justice, rather than the traditional one-size-fits-all approach traditionally taken by the common law. Equity by nature is deeply intertwined with moral principle and often goes beyond strict legal formalism to consider the context of human conduct and relationships. Hence, Sir George Jessel's recognition in Re Hallett's estate that unlike rules of common law purporting to stand from time immemorial, principles of equity are more readily susceptible to change in line with changing social conditions. We can see this distinction in the English legal lexicon, where we refer to the rules of law, but the principles of equity. This language reflects the key difference in substance between equity and the common law. As best put by the High Court of Australia in Jennings and Public Curator Queensland 1953, a court of law works its way to sort issues and confines its views to them, while a court of equity takes a more comprehensive view. As I mentioned in the foreword, which no doubt you've all read carefully, that is not to say that modern-day equity only contemplates perceptions of intuitive fairness. Over time, although the notion of fairness as the object of equity has not necessarily wavered, it has been tempered, shifting to established principles and precedent. For example, last year's decision in Mao and Bao in my court demonstrates that mere intuitive unfairness, as that term may be understood from a strict moralistic sense, is not sufficient in itself to justify the exercise of equitable set-off. An application for special leave in relation to that decision was refused by the High Court. So too you can see this concept in Australian Broadcasting Corporation and Lena Game Meats. This reflects the broader principle that equitable doctrines cannot be invoked simply to achieve idiosyncratic fairness on the facts. As put by the former Justice Gummow and Arian Mussini in their recent paper, The Use and Misuse of Metaphors, the phrase conscience has become a metaphor, or a term of conclusion, for the application of equitable doctrine. The second and perhaps more contentious fallacy is recognised widely as the fusion fallacy. That term was coined in the very first edition of Equity, Doctrines and Remedies published in 1970. At its root, the argument against fusion was historical. As I've already mentioned, solicitors in New South Wales were adamant about the strict administrative and substantive separation of equity and common law courts in an aim to avoid any form of fusion between the two jurisdictions of law. Although the English Judicature Act 1873 integrated the administrative application of equity and common law into a single court system, the Judicature Act itself did not fuse the substance of the two doctrines. Instead, equity and common law were described as two streams of jurisdiction, though running in the same channel, they did not mingle their waters. The strongest opposition to this imprecise concept of fusion was expressed in Marr, Gummow and Lehane's Equity, Doctrine and Remedies, where the authors identified that the Judicature Act did not affect any fusion, but merely altered administrative arrangements. The two bodies of law now administered by a single High Court were unchanged. As seen in 19th century England, the King's Bench Division and the Chancery Division were equivalent to the modern-day New South Wales Common Law and Equity Division. As such, when I was appointed Chief Judge in Equity, a very senior judge in our country wrote to me and said he'd never seen a Chancellor's foot like mine. But, to return to my theme, I would like to turn back then to the implementation of the Supreme Court Act 1970. While most Australian states enacted legislation modelled on the English Act, with Queensland enacting its Judicature Act as early as 1876, New South Wales only took this leap forward in 1970, with the implementation of the Supreme Court Act 1970, together with the Law Reform Law and Equity Act 1972, which combined the administration of law and equity almost 1 century after that had occurred in the United Kingdom. There have been long-term advantages, of course, to this strict separation. The biggest advantage is that such attitudes as prevailed in New South Wales produced generations of practising solicitors, judges and academics like Roddy Marr, Bill Gummow, John Lehane, Mark Leeming, who were, and in Gummow and Leeming's case still are, exceptional scholars and judges, producing well-known textbooks and academic scholarship devoted to equity. 1975 saw the first publication of Gummow and Lehane's Equity Doctrines and Remedy. This text is the preeminent publication on equity in both Australia and Australia and England, with the book now being in its 5th edition. To this day, New South Wales' exceptionalism in this field is why equity is taught as a separate subject in most New South Wales law schools, including the subject Equity and Trusts, which is taught at UNSW. To what is, I hope, none of your dismay, during the 1960s, in a time where law schools were under immense pressure to reduce compulsory courses to make way for a wider variety of optional subjects, with equity being a prime candidate for the chopping block, New South Wales's strong focus on equity was a leading cause towards keeping the subject compulsory and maintaining academic interest within the field. I would like to think that that is why the articles produced in this edition of the journal were of such high calibre, reflecting the strong focus on equity and the law that this state has traditionally held. Now, I won't spend too much time keeping you from your further beverages in running through the articles in this edition, but to align with the UNSW Law Journal tradition, I will do so briefly. And I have to say I found the edition to be a cohesive piece of work, doing well to tie in with the general theme of equity, conscience and commercial morality. First, and I'm doing this chronologically so as not to put anyone's noses out of joint, is the article Corporate Alter Ego Liability in Equity. Now, this does well to trace the development of alter ego liability as a new form of equitable third-party liability. The author's discussion showcases the dynamic evolution of equity, challenging fundamental principles of corporate separateness by permitting individuals to be held liable for the actions and gains of a corporation in circumstances where that corporation is simply, quote, the creature, vehicle or alter ego of wrongdoing fiduciaries who use it to secure the profits of or to inflict the losses by their breach, unquote. The authors identified that since the first reference by the full federal court in Grimaldi, the concept of alter ego equity liability has been recognised several times in Australian courts as a means of grounding liability. Cases such as this, by way of example in my court, can be seen in Oliveri Legal and Cassegrain Tree Oil, Ecopact and Law Society of New South Wales, and Murdoch and Mudgee, Dolomite and Lime, which is discussed in the article. I couldn't, in the second article, help but notice that remedies and the Baumgartner joint endeavour principle, aspects of the minimum equity rule, refers to a number of my past judgments. I didn't count up to see that there were references to 30 in the journal, however, so I have been statistically challenged on that front. But those include Austin and Hornby, Australian Building and Technical Solutions, and Bumelum and John Nelson Developments, and Focus National Developments. While I will not delve into the minutiae of these judgments, what I will say is that equity at its outset prized innovation, creativity, conscience and morality as the means to achieving justice. The common law at its outset prized continuity, precedent following, rationality and logic. Despite innovation being in many ways the obverse of historical continuity, the author has done well to channel the innovative equitable tradition, arguing that integral to the application of the joint endeavour principle is the minimum equity rule. Next article writing in 1989, the former federal court judge and one of the most esteemed scholars in the realm of fiduciary law, the Honourable Paul Finn, observed that equity has come to recognise fiduciary relationships and obligations as a new and coherent head of law, arising out of the pressure for its expansion due to the prevalence of fiduciary relationships in the law of commerce and the availability of relief founded in unconscionability at general law and by statute. In line with Finn's understanding of the link between equity and fiduciary relationships, the article terminating fiduciary obligations, is there a duty of loyalty to former clients, explores current tensions in the law regarding the disqualification of lawyers appearing against former clients, which hinges on the potential misuse of confidential information, an inquiry that touches on the very foundation of the legal profession. A solicitor owes a multitude of duties to his or her client, sourced in statute, contract, tort, and equity. Ultimately, courts of equity will supervise the activities of those persons who are placed in the position of fiduciary to prevent them from misusing their position and use of confidential information to their own advantage. It's my court, however, who strikes them off the roll. I withdraw that comment. Historically, trust law in New South Wales, like much of common law tradition, has been underpinned by the equitable doctrine that trustees are bound by an uncompromising fiduciary duty. This principle, tracing back to 19th century English case law, requires trustees to act with the utmost good faith and bear full liability for breaches of fiduciary duties. Matthew Conaglan, in his provocatively titled article, Proportionate Liability for Breach of Trust under the Civil Liability Act, an opiate on the conscience of trustees, investigates how the proportionate liability scheme contained in Part 4 of the Civil Liability Act 2002 has the potential to alter the internal workings of the Office of Trusteeship. The author posits that this statutory regime may serve as a Trojan horse. While considered ostensibly fair, the scheme may erode foundational principles that once compelled trustees to adhere to rigorous standards of care and responsibility. While I'll reserve my judgment on this debate, it should be apparent that reasonable minds can differ, and it provides an intriguing academic contribution to this legislative debate. In talking of fiduciary duties, of course, and trustees' liabilities and obligations, we will all be no doubt eagerly awaiting the High Court's decision in Jakin nominees, but it hasn't yet come out. I don't know if it'll be out before the end of the year. Rather, today's triumph was the High Court dismissing an appeal from my judgment in Kramer and Stone on estoppel by encouragement. Back to the topic. We then have an article entitled Pushing Equity's Envelope, probing the arbitrary distinction between immoral and unconscionable commercial behaviour. This not only effectively traces the emergence of equity, but also surveys the contemporary doctrine of unconscionable dealings. In so doing, it considers how various forms of seemingly immoral commercial behaviour have been deemed to fall short of the threshold for unconscionability. For example, the author refers to the practice of price gouging, where businesses significantly raise prices during times of crisis and increased market demand. The paper is timely given the ACCC's 2024-2025 inquiry into the Australian supermarket sector and separate proceedings commenced by the ACCC in the Federal Court for supermarkets allegedly breaching Australian consumer law by misleading consumers through discount pricing claims on common products. We'll have to wait for further judicial adjudication on this matter, but nevertheless the author's exploration highlights modern-day tensions between equitable legal principles and moral expectations in contemporary commercial dealings. The next article on corporate whistleblowers and financial incentives also focuses directly on the intersection of commerce and moral principle. The authors argue in favour of an award-based approach to the implementation of future whistleblower-based reform in Australia, similar to that of the incentive-based model in Canada and the United States of America. Again, this paper is timely given that the Senate Economics References Committee has handed down its report on the operation of ASIC and recommended financial incentives and compensation for whistleblowers. The Commission found that in the US, more than $6.3 billion in monetary sanctions was imposed as a result of information provided by whistleblowers to the United States Securities and Exchange Commission. Nevertheless, while incentive-based schemes for whistleblowers like those in North America present an opportunity to promote an increased level of accountability in corporate law, they must also strike a balance between practical benefits, cultural values, and ethical considerations. So we then come to the more general articles. Is one entitled "Is the For-Profit Corporation a Slave? Lessons from Mary Shelley's Frankenstein," which asserts that modern-day corporations, while owing their inception to their directors, shareholders and executives, can, like Frankenstein's monster, take on a life of their own, engaging in antisocial behaviour and causing harms in ways that their creators may not have intended. Wallace's argument in this article provides a timely reminder to recognise the ethical implications of corporate power, reminding us that, like Frankenstein's monster, unchecked corporate power can lead to far-reaching consequences, leaving society to bear the costs. Then there is an article on ending segregated employment for persons with disabilities, the case for federal social cooperative legislation in Australia, which explores general principles of commercial morality in the context of a new federal legislative scheme applicable to persons with disabilities, and addresses a case for the phasing out of the Australian disability enterprises by highlighting the efficacy of a social cooperative business model. The paper advocates for a shift towards businesses that prioritise social outcomes. Also with a focus on those with disabilities is the article on disability discrimination in education, investigating the ADR experiences of parents and practitioners, which examines the effectiveness of alternative dispute resolution in providing for disability-related education complaints. The analysis points to ADR mechanisms, such as mediation and negotiation, as a flexible and accessible route for resolving disputes, but also questions whether those processes offer the equity and protection needed in sensitive contexts like disability and education. Together, both of those papers underscore the importance of embedding social responsibility within legal structures that govern disability in Australia. Finally, and in a very subtly disguised take from a book you may have read in the library on some occasion, titled "Fantastic Precedents and Where to Find Them," an argument for limiting the operation of common law binding precedent rules when interpreting the UN Sales Convention, the author analyses the magical but often elusive way in which the goal of the CISG to harmonise international trade law through universal application may be thwarted when interpreted by reference to Australian domestic contract law. It's noted that Australia has been famously described as having an opt-out culture when it comes to the CISG, in contrast to our largest two-way trading partner, China. And then, to close, I should say this. I was asked today to speak about the development of equity jurisprudence in the place of moral reasoning in commercial law. History has shown an evolution from a process of interaction, contemplation, re-evaluation and correction that is necessary in seeking to strike the appropriate balance between rule and principle, certainty and predictability, justice and fairness. The judicial method in equity, so far as any such method can be said to exist, is to mediate between the rigours of the law and of conscience, placing fairness, justice and unconscionability as the thematic force of the jurisdiction. And despite 200 years of transformation in the Supreme Court of New South Wales, this is what judges have consistently been called upon to do, day in and day out when they decide cases. Each judge has his or her own method, context and circumstance may be given different weight by different judges, and reasonable minds may differ. To my mind, the power of equity is that it assists judges in finding the appropriate focal length from which to view any given dispute, so that the just, as opposed to the purely logical, outcome may become clear. I'm very pleased to launch this issue of the UNSW Law Journal. I do not propose to smash a bottle of champagne over the covers of my copy of the journal, but I would ask all of you in due course to raise a glass to the authors, the editors, and all those involved in the production of what is a really wonderful summer holiday read that Rowan has already read, so he doesn't need to read it again. May it continue to stimulate the discussion of equity within the legal profession. Thank you.
Thank you very much. My name's Andrew Lynch, and I'm the Dean of the Faculty of Law and Justice at UNSW. And my traditional role in these proceedings is to offer a vote of thanks to our speaker, and then some other thank yous as well, and acknowledgements before we then take up the offer of further beverages, as we said before. So it's a great pleasure to be with so many of you tonight. So I will certainly begin by thanking Justice Ward for her comments tonight. She said to us she was going to take us on a voyage from 1824 through to the 1970 enactment of the Judicature Act of New South Wales, and she certainly did that. And in fact, I didn't feel any apology was needed for the plugging of Constant Guardian, which is a magnificent book. Perhaps if you have not seen it, then please put that on your Christmas wish list. Plenty of summer reading there with pictures as well. The Constant Guardian is a remarkable production of the Supreme Court to acknowledge the 200 years tradition of justice in this state. And in many ways then, Your Honour was already a very welcome person to give the address tonight, but a perfectly timed one, really, given the topic that you chose to speak to. The other connection that UNSW has with Constant Guardian is that one of its two co-authors is Keith Mason, who had been president of the Court of Appeal and then spent many years as a visiting professorial fellow amongst the faculty in UNSW. It's been a night for astonishing kind of secrets and past reminiscences, and Rowan gave us the one about his precocious behaviour as a 6-year-old and colouring. My secret isn't of that kind. And it is known by my colleague Professor Simone Degerling, who threatens on occasion when she struggles to find enough teachers for equity and trust to invoke it, in that very, very early on in my academic career I did teach equity and trusts and even had enough of a passing knowledge to be a co-author on a textbook on that topic. So whenever I hear an address such as the kind that we've heard, which I think plays very much to the passion for history that lawyers have, and I think equity is an area that really rewards those who are particularly keen on history, legal and otherwise, I feel that I have taken a wrong turn, and my early years in equity and trusts, which were mainly broken by the trust part, not the equity part, and the teaching of the 3 horrible cases that I still recall. It's a real pleasure, and so that secret goes a lot further back than 2009, and that was many years ago, but it is one of those things to revisit, and certainly my pulse quickens at the mention of a fusion fallacy, and I still think maybe one day I can return to those pastures. So thank you, Judge, for such a wonderful and stimulating address, which gave us so much to think about, and in addition to your comments on the voyage of history that we took, you then did a tour de force, really, in terms of our treatment of all the papers that are collected in this fine issue of the journal. So thank you for that précis as well of its contents. And that leads me to congratulate the authors who are here tonight. And there are, I think, many authors, including those who have travelled from interstate. And it's really wonderful to be joined by authors of the journal and to hear their work talked about in the moment, as it were. So congratulations to all of you. There is no journal without authors. I know that may seem very obvious, but the quality of the journal is due to many things, and I'll come to one of the things that I certainly think it is about. but it is certainly due to the quality of the papers that are submitted to it and the work of reviewers of those papers to ensure that that very high quality on submission is lifted even further with the final product. So we definitely know that the reputation of the journal depends a lot on the willingness of authors to trust us with their hard work. And so I think that cycle of virtue, whereby the trust of authors is repaid by being so well looked after by the journal's editors and the inclusion in such fine publication and alongside other fine papers. So that it is one of those few journals that someone can pick up and actually want to read article after article, is a testament really to how much has been achieved in 47 volumes. I obviously want to thank our hosts at King and Wood Mallesons and Damien for his remarks earlier. The long sponsorship of the firm is deeply appreciated. The quality of the finished product is really entirely due to the generosity of the 4 premier sponsors: King and Wood Mallesons, Coors Chambers Westgar, Allens and Herbert Smith Freehills, and we're grateful for the steadfast nature of that support and also your generosity in hosting us tonight. I also want to acknowledge my colleagues, of whom there are many here, and their presence at these events is evidence of the huge pride that the faculty has in the journal and in our students, who, as has been said, independently produce the journal. The work of Gary Edmond and Ros Dixon, who unfortunately can't be here tonight, is really critical in supporting the editors, but I'm sure Gary would agree with me that it is a support and advise function, but it's not a doing function. The journal is done and produced entirely by our students, and it is done to an incredibly high standard of professionalism. So now to the journal and all involved. Thank you to everybody who has worked on volume 47, issue 4, and congratulations. Again, the miracle has happened. The journal is produced. It is produced on time. Only once has there been a launch where the journal didn't actually make it. And every launch is memorable in its own way. And that was not in any way due to the efforts of the team. But even through COVID, the journal was produced. It is the thing that is most reliable certainly in university life that I have found. And I congratulate every member of the team who has been involved. Obviously, there are some special mentions. Rowan, this is your issue. Congratulations on being the youngest editor of an issue of the journal, and for your achievement. And it really is, I thought your speech, apart from taking a lot of material that I was then going to use in terms of thank yous, really articulated your clear vision for what you wanted to achieve, and was very generous then in saying really the collaboration between yourself and the contributing authors, and you painted that picture very well for us. Sharanya, I really want to thank you as the executive editorship draws to a close. That is the marathon role on the journal. You have led a remarkable team through 4 successful issues, the digital copy, the forum. The work of the executive editor is a really incredible task, and I do want to hear Rowan more about Snow White analogies and to see how that plays out. But I think keeping everybody onto the job, keeping morale up, and also being the face of the journal between the faculty but also to the profession. There are many responsibilities from that, and you have acquitted those perfectly. So congratulations on your year. A last word really on why I am so passionate about the journal, and it's really answered by looking around the room, because I can see amongst the audience former editors from previous years, people who are now in the profession, now graduated from the university, obviously the current crop who I've been engaging with over this year. But what was wonderful when I arrived tonight, and at the risk of embarrassing Ivy and Oscar, I caught the lift with 2 students who are at the end of their first year and were attending this to learn more about the journal. They were very interested to know more about what this publication involves and the chance of being involved in it. And that continuity between some of our very newest students to those who are close to finishing their degrees with us, and to those who have gone on into the profession and in other walks of life. It's a really remarkable tradition to be a part of. I congratulate every single member of the student body who contributes to the journal. As I did say, the faculty reflects in the success that you achieve for us. Thank you very much, everybody. Thank you, Judge, again for your comments, and congratulations. Good night.
Thank you very much, Professor Lynch, for that heartwarming vote of thanks, and thank you, President Ward, for your entertaining and very informative keynote address. As Issue 4 has officially launched, this marks the conclusion of Volume 47 of the University of New South Wales Law Journal and the conclusion of tonight's official proceedings. Please feel free to remain and mingle for the next 20 minutes or so, and please do not forget to collect a complimentary copy of Issue 47.4 for your summer reading. All of the articles in this issue can be found on the UNSW Law Journal's website from tomorrow. Thank you all for attending, and good evening.